Hi there, you're watching BloombergQuint, and this is the fine print. In a decision that's unlikely to bode well for shareholder activism in India, the Bombay High Court last week injuncted Invesco from acting upon its requisition for an EGM of Zee Entertainment's shareholders. Now, a quick recap of the matter at hand. Invesco Developing Markets Fund and OFI Global China Fund together hold a 17.88% stake in Zee. As per company law, any shareholder with more than 10% stake can seek an extraordinary general meeting of the company. If the board declines, the shareholder can convene the EGM itself. In September, Invesco and OFI sent a requisition to Zee's board to convene an EGM for two purposes: to oust Managing Director and Chief Executive Officer Puneet Goenka and appoint 6 new independent directors. The board refused, and even as the matter was pending before the National Company Law Tribunal, Zee approached the Bombay High Court with 3 requests. First, declare that Invesco's requisition is illegal, invalid, bad in law, and incapable of implementation. That Zee's refusal to act on it is in accordance with law, valid, and justified. And finally, grant an injunction against Invesco from acting on its own requisition. Now, last week, the High Court passed an order on Zee's third ask, but the order reads almost like Invesco's fate is sealed on the first 2 as well. Now, whether or not my 2 guests today feel or read the order in the same fashion, let me go across to them. I'm joined by Umakanth Varottil of NUS and Rajat Sethi of SNR. Rajat, Uma, welcome to the fine print. Rajat, I'll come to you first, and this is just to get this out of the way, and for also sort of clarity's sakes, the 3 sort of asks of Zee that I read out that they had gone to the Bombay High Court with. The order states that it only pertains or talks about its third ask, which is the injunction against Invesco from acting in furtherance of its own requisition notice. Are you also reading the order, but in sort of giving the injunction outcome, are you also reading the order to believe that the first 2 asks of Zee will also be granted in favor of it, if at all, the single judge bench gets to hear those 2 counts, given that the division bench has already been approached by Invesco against a single judge's order?
Yes, so I think Paiswani, thank you. I do feel that once the judge has granted the injunction, then the judge has indicated broadly that he agrees with the submissions which have been put forward by Zee in relation to all the questions, and in relation to whether the resolutions which have been proposed are illegal or incapable of being implemented. I think the judge has formed a view on those matters and then proceeded to grant the injunction. As you said, obviously the judgment has been appealed to the division bench. So one will wait and see what the fate is in the hearing before the division bench. But as far as this judgment is concerned, Paiswani, I read it to be a resounding success for Zee on all counts, including on the legality or illegality of the resolutions proposed, and also the board's refusal to convene an EGM once the requisition notice was received by them.
Right. Yeah, I mean, that's why I was curious that why the court order says that, hey, the order pertains to the injunction request, because it didn't seem to me that there was room to say anything else. Uma, let me bring you in. I'll come straight to the sort of question that it's at the heart of the issue, which is Section 100 of the Companies Act. And briefly, it's sort of like I mentioned earlier, allows shareholders with over 10% to call and to sort of ask the board or the company to convene an EGM. And if the board refuses, within a certain timeline, the investors can call, or the shareholders can call that EGM themselves. Of course, now Invesco has been injuncted by the Bombay High Court from moving further on its requisition. But do you believe that an important shareholder right has been taken away, given that, and we'll discuss that further, given that what all the Bombay High Court has said in terms of things that need to precede Section 100 right, or needs to be fulfilled by a shareholder before exercising this right under 100?
Thanks, Paiswini. Just two parts to your question. I think the first one is why the injunction? The injunction is because Section 100 gives a right to a shareholder holding 10% shares, in this case Invesco, to go ahead and convene the meeting itself without having any recourse to the board if the board doesn't hold the meeting. So therefore, that's exactly the real bone of contention in this case. And as Rajat also said, perhaps the tests would remain the same even for the final outcome. So that is really what the court has injuncted. Now, what does this do to the rights of the shareholders under Section 100? Certainly, this decision severely undermines the rights of shareholders because this is a very important right that shareholders have under the Companies Act. If the board is not convening the meeting, then the shareholders can assuage their complaints by bringing it to the other shareholders, and that is possible only when the shareholders can convene a meeting. So this EGM requisition is an important voice given to shareholders under the Companies Act. This voice is usually exercisable when there's a conflict between the board and a shareholder, which is clearly what is the case in this particular instance as well. So the impact of the order, the somewhat extreme nature of the order undermining these rights will certainly have an impact in a negative sense on the concept of shareholder activism in the Indian context.
Okay, if I were to, since you and Rajat from our pre-interview conversations seem to sort of believe that this judgment has taken away a very important shareholder right, if I were to play Rajat the devil's advocate here and say that at certain places, the judge has sort of explained his the why of he came to this conclusion. He says that if a shareholder proposes, let's say, anything during the hearings, and even that's recorded in the judgment itself, let's say, resolutions like can or should Z venture into online gambling, or there is an illegal action that is expected or proposed as a resolution by a shareholder who meets the threshold of over 10%. Is it sort of at all unfair for the board to sit in judgment of such requests? The court seems to have come to the conclusion that the board has every right to look at the resolutions from the prism of legality. And given how and the requirements that, let's say, listed companies are supposed to follow under various guidelines, whether it is the market regulator, company law, and maybe even sectoral regulators, does this interpretation give a wide canvas to Indian boards to turn down EGM requisitions on some or the other ground?
I would think so, Paiswini. I think the example that you gave, where there is a object of the resolution, for example, in which the judge gives, is online gaming. Okay, assuming that it is illegal. The position on online gaming is also far from certain, but assuming that in the state of Maharashtra, it's illegal for a moment. So in those kind of situations, I think if that is the limitation, I think that would be a fair limitation. I don't think anyone is able to question that if the object of a resolution is to engage in a criminal enterprise, whether it's online gaming, which is illegal under the laws of the land at that time, or whether it's some other resolution, then I think there could perhaps be a case for the judge to conclude that in a particular case, the board can refuse to requisition a meeting. But the question then is, can the shareholders themselves still requisition the meeting? The judge has obviously injuncted the shareholders themselves from requisitioning a meeting. And on the illegality part, Paiswini, the question I have is this the case where illegality is made out? So the question, I feel, may not have been so much on the law, but the question may have been also on the facts. So I feel that illegality, even assuming an illegality standard had to be accepted, that obviously the board cannot be expected to do something or support something which is illegal. Even if that standard were to be accepted as an appropriate standard for the board to consider in requisitioning a meeting, I do believe that the facts of this case required further analysis as compared to what I see in this judgment currently.
Okay, Uma, you mentioned that there is a conflict built into Section 100, right? That it sort of contemplates a situation where the board says that we're not approving this requisition request or notice, we're declining it, and the shareholder then has the leeway to call or convene that EGM itself. And as the hearings were proceeding, it seemed like this is, the way, or this is the direction even this bench was headed towards. But the outcome seems to have been extreme. Given that the judge has said, and it's a very interesting line that he says in his order, after summarizing Z's 5 or 6 legal infirmities that Z argued in this case, the judge says, I agree with Mr. Subramaniam, which is Gopal Subramaniam, who is his counsel in this case, on all counts, whether it is the supposed or the alleged violation of company law, whether it was SEBI's listing regulations, whether it was the takeover regulations, or it was company law. The judge says, I agree with Mr. Subramaniam on all counts. So given that, the court has reached this conclusion, what manner do you think a shareholder can realistically exercise this EGM requisition right?
Thanks. Again, here coming back to this question, certainly as far as the order is concerned, the interpretation of the law is in a way accurate, because certainly the Companies Act doesn't say that resolutions which are brought under Section 100 need to be legal or not illegal, but that's something that can be inferred from common law. But the question is how, as Rajat mentioned, how has that been interpreted in this particular case? And here I would like to make a distinction between illegality and conditionality. Right? So the example of online gambling, provided that online gambling in a jurisdiction is illegal, is clearly a case of illegality. No shareholder can be allowed under Section 100 to bring a resolution to request the company to carry on online gambling. But if the resolution requires certain procedures to be followed before they can be made effective, that does not make it illegal. It is just that certain procedures, certain conditions need to be satisfied. Perhaps Ministry of Information and Broadcasting approval is required. If the takeover code is triggered, the takeover code needs to be complied with. If competition law is involved, competition law needs to be complied with. So that would not necessarily be a case of illegality per se. Those would be cases where certain conditions need to be followed. And now that may have very well been the case even if the board itself had proposed a similar resolution. So the same logic can be reversed on its head to say, if the shareholder cannot bring a resolution that the board cannot bring, if the same conditions that apply to the board should also apply to the shareholders as well. So here there's a distinction between illegality and conditionality. And here there is less discussion in the judgment on individual aspects of these requirements, which the court, as you have suggested, accepts these counsel's arguments and does not get into the detailed factual analysis of this. So I think this is a very important question that I suspect will come up on appeal. Even assuming that illegality is a consideration, are these 6 or 7 grounds that are raised here, do they elevate themselves to a level of illegality? Or are they only certain conditions to be satisfied, failing which there would be non-compliance with the law? So despite the outcome and the passage which you read out, I think this would be the discussion. And if we don't arrive at a satisfactory resolution regarding these points, I think that will raise a whole lot of issue from shareholders' activism point of view, because every resolution that shareholders bring in a listed company will be subject to some condition or the other. And that per se cannot be a ground for rejecting the exercise of the right under Section 100, which might be the implication if we read this judgment plainly. without getting into the details as we have done just now.
Okay, Uma, I do want to get into this a little bit deeper. Okay, so let me sort of reiterate some of the arguments that the court seemed to agree with that Z made. Z said Invesco's proposal on changes to the board will require prior approval from the Ministry of Information and Broadcast. It said that the proposals violate SEBI's listing regulations, which mandate a nomination and remuneration committee-led process for appointing independent directors. It said that it violates company law that requires the managing director and CEO or whole-time director on the board at all times. And if Goenka is removed, it will leave a void on the board, which is not acceptable. It also argued non-compliance with takeover code, competition law, etc. How could a harmonious interpretation of this very important shareholder right under Section 100 and these processes would have worked, let's say, in this case?
Yeah. So just to give you one example, so let us take this question of whether a nomination and remuneration committee has to approve these candidates that were proposed by Invesco before the EGM can consider them. Now, this is a very valid point, and I don't. It's a valid ground that the Z has raised in this case, but it perhaps requires a little more analysis. And here, on the one hand, you have the Companies Act under Section 178 and the SEBI listing regulations that you mentioned, Regulation 7, which require a nomination and remuneration committee to screen the independent directors. And on the other hand, you have Section 100, which gives power to shareholders to exercise several rights, which they could have done in the shareholders' meeting. It's just that Section 100 gives them the right to call for a meeting. Now, rather than to say that because a nomination committee needs to approve an independent director, shareholders can never propose an independent director, that is an extreme position. What I would have thought would be a harmonious interpretation of these two sections. Nomination remuneration committee usually has to come out with a policy. What kind of independent directors do they want on the board? What kind of aptitude, expertise, skills, qualifications are they looking for? So companies do have these policies that are there. Maybe one way of looking at it would have been to just examine whether these candidates satisfy that requirement or not, rather than to simply say that shareholders can never propose these candidates in the first place. So that's the first point. And the second and important point that you raised is whether by removing Mr. Goenka from his position, the company will cease to have a managerial leadership position. Now, Section 203 of the Companies Act says a company needs to have a managing director, chief executive officer, or manager. It can be any one of these three positions. Now, interestingly, what is the resolution that's proposed by Invesco seeking to do? It's seeking to remove Mr. Goenka as a director of the company, not from his managerial position. Even though he's removed as a director of the company, he can continue to be in a managerial position, not on the board, but still satisfy the requirement of a manager. So perhaps this doesn't seem to have been articulated in the decision, or perhaps I'm not aware in the arguments, but this could have been a more fine way of looking at this issue, because there are answers to that as well. And there are also perhaps other ways of looking at the issue of takeover code and competition law. Arguably, that one needs to consider whether this exercise of right by Invesco, does it even amount to change of control or not? So what we find in the decision is just an acceptance of what the council argued. Perhaps the question of illegality might require a lot more detailed analysis of each one of these counts. But perhaps then we might come up with a different outcome in those circumstances.
So, Rajat, coming here, if you agree with Uma, then 100 is not a very simple right for a shareholder to exercise. Even assuming, let's say, Invesco finds some sort of success at the division bench level, or let's say if it goes to the Supreme Court, it's no longer a very simple exercise of a right under 100, because let's say the board says, no, it's not as if you can then go ahead and just call that EGM. You will be then called upon to explain or to show and to even meet some of these criteria before you can even go ahead and take the resolution to other shareholders of the company. So realistically speaking, as an outcome of this order, let's say we are in a situation where even the court says that if the board has refused, yet the shareholder can call it if it meets XYZ criteria. So shareholders should be prepared to do all this exercise before they go ahead and call an EGM under 100?
I think it has to be the other way around, Payaswini. When a shareholder exercises a right under Section 100, then it is incumbent on the board or on a court granting an injunction to establish an illegality. It's not incumbent on the shareholder to say that I satisfy XYZ criteria. All I need to do as a shareholder is that I need to have 10% shares, I need to sign a requisition, and I need to deliver to the company at the registered office. I would say the presumption is that it is an appropriate resolution if I satisfy those criteria. If anyone wants to stop me, then the board or the court, whatever the case may be, has to come up with the reasons, which have to be very compelling reasons indeed to defeat that right. I don't see on the record of this case, based on the single judge's judgment, enough material considering whether the objections which have been put forward by the board are indeed meeting that standard or not.
Okay. Uma mentioned one point, Rajat, that the court has not dwelt on why it has found these conditions, the non-fulfillment of these conditions to be an illegality and not just, let's say, conditions that can be fulfilled by Invesco or the board itself. Invesco maintained all along through the hearings that the reasons for why it's calling a requisition under 100, a court cannot sit in judgment of that. Did Invesco hurt its cause by not arguing along the lines that these are not sort of conditions or requirements that make my requisition as Invesco and OFI illegal?
Yes, I think so, Payaswini. I would agree with you because the Invesco arguments focused entirely on taking a very extreme position that I, as a shareholder, am entitled to requisition a meeting because I hold 10% of the shares and meet the technical requirements of Section 100. And no one can look into the object of the requisition in order to disentitle me from exercising that right. There is some old case law which supports that position. Invesco, however, does not, at least based on the judgment itself, does not seem to have engaged with the court on the next level, which is assuming that there is a standard of illegality, then that these resolutions do not fall into that category. And as Umakanth is saying, perhaps there are conditionalities to be met or there may be irregularities, but that does not make the resolution illegal. In fact, the shareholder here is asserting his right. So of appointment and removal of directors, I don't see how that kind of a resolution can be illegal. If there are process-related issues, etc., then those process-related issues, there is an appropriate resolution for those. Takeover Code, Competition Act, I don't see any analysis in the judgment on how these resolutions violate the Takeover Code or the Competition Act. Those would merit judgments on that issue on their own. I don't see any of that analysis except some very bold assertions that these are violative of the Takeover Code and the Competition Act. At least the judgment does not indicate it. So I think you're right in saying that Invesco perhaps argued an extreme position, and the judge and the court, it was very easy for the court to reject that extreme position. So perhaps a more centrist approach where Invesco also engaged with the court on facts and on rebutting the arguments which had been put forth on those 6 or 7 points by Z, that might have led to a more balanced judgment.
Okay, Uma, I found one bit very interesting in this order where Justice Gautam Patel says that if a resolution cannot in law be given effect to, courts must intervene. It's not that shareholders' rights are curtailed or abrogated, or they cannot seek what they do now, but the manner in which they go about it must be legally compliant. Am I reading too much into it to probably interpret this to mean that there is a suggestion to Invesco here that maybe you can fulfill X, Y, Z, and maybe still go ahead and do this, EGM or convene this EGM? Given that at one point he says that shareholder-driven shareholder primacy or dominion does not extend to permitting shareholder-driven illegality. There's certain conflicting sort of, let's say, language in the order itself, where I'm not sure if there is at all a subtext to it to say that if Invesco would have, made sure that A, B, C are fulfilled, it could have called that EGM. Am I reading too much into the language of the order?
Yeah, I think maybe it would be difficult to ascertain the judicial mind from this particular language itself, but I could imagine a certain other element coming in. So, for instance, the judgment deals with in greater detail about not only the fact that the resolution needs to be something that is legal, but also something that is capable of being implemented and is something that can be made effective. So I would try and read the language that you just read out along with that, which means that the resolutions proposed must be capable of being implemented. Now, this I think is a little more unsettled. This area of the law is a little more unsettled than the illegality issue, because again, the court adopts principles from the UK Companies Act, where there's a language in the statute which specifically says that the resolution must be something that is capable of being implemented. Whereas the Indian Act does not have that, although Justice Patel does recognize it in his judgment and says, even though Indian statute doesn't have it, it is part of the general law itself. So to me, yes, in the context of that discussion, that the resolution is something that needs to be implemented or capable of being made effective, I would tend to think that that language is something that might be a suggestion to say that, maybe if certain steps are followed, that would be the case. But again, I don't want to read too much into it, because we can only interpret based on the written word of the judgment and perhaps an idea of what the arguments were like.
Well, I mean, arguments didn't give at all an indication, to be honest, since we reported live from all the court hearings that the court will take this extreme view, because in its sort of questioning to the counsels, the court seemed like, to also acknowledge that it's an important right under 100. But sort of personal observations apart, Rajat, coming here with your final views on how this is likely to proceed at the division bench stage, what could be some of those grounds that you foresee will get articulated by Invesco at the division bench?
I think all of these points which we've been discussing, Payaswini, I think the foremost ground ultimately has to be, and of course they will make the initial argument again, that the object of the requisition is not relevant for purposes of Section 100. And a shareholder is entitled to call the meeting. The illegality standard is not embedded in Section 100. So come what may, that shareholder meeting must go ahead. And then it is up to the shareholders to determine whether what course of action is appropriate and legal, and whether they should vote in favor of the resolution or not, or whether they should vote in favor of an amended resolution which complies with the law. So that, I think that argument they would repeat again. But ultimately, I think from the perspective of an outsider who would sort of hope that this leads to some good precedent, I think it would be helpful to have further clarity on what precisely the standard should be in relation to the board deciding to turn down a request for requisition of a meeting. And that has to be a very high standard. It cannot be some amalgamation of different themes which are picked up from different case laws. It has to be a precise standard. So illegality, I understand that one cannot quarrel with beyond a point. But if indeed there are any other standards, then I would hope that the division bench sort of provides some light on those. And ultimately, a resolution of this matter, I think, on the grounds of appeal, just going back to your question, I would think that Invesco would want to focus on each of these 6 or 7 grounds and establish that it is not the case in the present situation. Umakanth already pointed out on section 203 on management personnel. On the face of it, there is no violation of section 203. And indeed, once the board has been reconstituted, the board could well, even if there is no manager in place, the board could well on day one appoint a CEO, even if Mr. Goenka has been removed from the position of manager as well. So I don't quite see, I think the judgment sort of jumps a few hoops, and in part it may well have been because Invesco did not join issue on all the factual points. But I think in the appeal, they would focus more on the factual points as well, apart from the legal issues.
Okay, all right. Well, my final word to you on, what this court, we started with that point, and I want to end with that point, because this is Section 100 is more than what sort of Z and Invesco are at dispute about. What does it do to the cause of shareholder-led governance on Indian boards, given that we know we have a very sort of, the DNA is of Indian businesses is promoter-driven. Boards are largely sort of, while independent, may not always speak their mind as freely as they'd like to. And we have a 4% promoter here, and here we're then dealing with an outcome like this. And if standards are set that investors, before they make a requisition like this, have to, ensure that these 10 processes or these 10 or 12 or 15 laws are met before they can even take it to the larger set of shareholders, is that too much to expect?
Thanks. So you're right. In this case, the fact that Section 100 could not be invoked at all in a blanket way is certainly a setback to shareholder activism. But where we would like to see this going, we don't want also the other extreme where shareholders can bring any and every resolution and disrupt the company. So that's also not a good outcome to be. So I think hopefully, and in response to the question that you also asked, Rajat, I think in terms of the appeal and the way the jurisprudence progresses, what we might like to see is a set of conditions, a set of guidelines, and an environment in which shareholders can bring these actions, provided they satisfy certain requirements. And today there's a lot of ambiguity on what those conditions are, what is illegality, harmonization, and so on. So I think what we would like to see in the appeal is some kind of a clear guidance on what are those conditions that shareholders might have to satisfy. And again, I agree with Rajat that the onus is not on the shareholders. Shareholders have this right to exercise under Section 100. It's for the company to put out the facts regarding illegality, etc. But what those facts are, what those guidelines are, I think that's where we need to see something going. And hopefully that outcome will make things clearer for the Indian context. So I think what we're looking for is more illumination of what the law is and what the rights of the shareholders are in these kind of shareholder activism cases.
I have a quick follow-up question. Let's say this illumination comes to you, Uma, comes to all of us via this order, via, let's say, in an appeal order. How will it practically work out? Let's say the court says these are certain conditions, as you pointed at the beginning of your response, that these are conditionalities and not really, illegalities that would sort of prevent Invesco to go ahead and call that EGM. How will that practically work? Will the court tell the board, hey, look, if you think these are illegal, make sure in a harmonious way that, you take approvals, you take sort of, or you subject the outcome of the vote to the fact that, look, only post these approvals, these decisions will be implemented. The onus will finally come on whom? The board to do it? And will it always have to be court-driven in an acrimonious situation like this?
In an acrimonious situation, I think it's going to be difficult. It will probably have to be through the intervention of the court. But I think end of the day, where it might land up is the board may have certain role to play as well. So currently what we have found is the board has simply said none of this is possible, and the court has pretty much agreed with that. So we see a kind of a situation where the board has been vindicated in one way and the shareholders have been completely out. Where would we would see this, what I'm referring to as harmonization, for example, is some kind of a role on the board itself to do some screening, maybe to cooperate to some extent with the shareholders, because the directors ultimately are fiduciaries in the company. So they can't simply take a stance saying that we don't like the shareholder, we are only going to act in a way by which we are definitely making sure that the shareholder will not succeed. That kind of a situation cannot, it will not entail, because directors have to act in their fiduciary interest and in the interest of the company. Now, that jurisprudence hasn't developed in the Indian context as much as it has in other parts of the world, but I think that's where we would have to come guidelines to the directors on how they should act in scenarios like this. I think that's the practical scenario. So, for example, since you asked about practicality, maybe the nomination committee will have to, in good faith, consider the veracity of these candidates according to the policies which they have set up. They can't simply say, we don't like these 6 names suggested, we're not even going to look at them. That's not possible, but they may have to genuinely consider these names. So that would be one practical outcome.
Sure. Thank you, Uma and Rajat, both of you saying that a standoff clearly is not the answer between board and a shareholder which meets the threshold, at least numerically, under company law. Thank you both for joining us with your thoughts on the outcome and the impact of this Bombay High Court order. We'll, of course, keep track of the story as it progresses before the division bench at the High Court. Thank you so much for tuning in to the discussion.
Thank you.